Married women, it is possible for you to get half of your husband's property during divorce. Many people have, many women are scared all because, they invested in a marriage and they devoted their life in that marriage. But, when the man was buying properties, he bought properties maybe in his name and he hid the title document of those properties for you. So he has threatened you that when you are leaving this marriage, you are leaving empty, you are leaving with nothing. It's a lie. Yes, it is clear that property sharing is not automatic. That you must prove certain things, yes. But I want to address cancel right in this video. Now, the case of Agulu versus Agulu has been misunderstood. Go and read that case proper. What the court held there in that case, first of all, you must understand that these people, these parties have been separated for 22 years. Now, the court went further to say that the settlement of properties equally, sharing it 50-50, is not automatic. The court held that you must prove actual contribution. The court went ahead to state it there that contribution need not be financial. Now, this was the decision of the court. In the instant appeal, there is nothing before the court to demonstrate that the parties who have lived apart for more than 22 years should share everything one of them owns 50-50. The appellant therefore cannot merely state that the court must make an order for settlement of the matrimonial property on a 50-50 proportion without showing the court material facts upon which to believe that such order will be just, fair, and equitable. It is correct that contribution need not be financial as stated in the authority of Kefi versus Kefi, 1986, 3 Nigerian Law Weekly Report, part 27175, which both parties rely on and argue in their brief. However, it is required that the appellant, that for the appellant to lay claim to what she referred to as matrimonial property, she would need to demonstrate such entitlement beyond being merely married to the respondent, a marriage which was deserted for some 22 years ago. What the court is saying is that you cannot wake up one morning after deserting a marriage for 22 years ago and you want to claim the man's work. What the court is also saying is that you must show material facts of your contribution, and this material fact must not be financial. Maintaining the home front, taking care of children, raising the children, can also be seen as material facts. So the law has not changed. The law is still the same. The problem is that many of you do not appreciate the law. In this case, this person was relying merely on the fact that they were married. Oh, I'm married to you, therefore I must take half of the property. And the court said no. You must show contribution. And that contribution must not be financial. That's the position of the law. Please don't allow anybody to deceive you. Share this video to your friends so that they can learn from it. Financial contribution is not a must. You can contribute in other ways when it comes to matrimonial properties.